Welcome, everybody. Thank you all for attending. As you know, today's topic is to strategize about options for dealing with the FTC's non-compete rule that would purport to ban non-competes. At the moment, that rule is scheduled to go into effect on September 4th, though it is being challenged, and we'll talk about all of that. For the audience members, one thing that's very important to know is we have an outstanding panel of true experts from around the country. These are people who litigate these matters and advise and counsel on these matters literally in every state in the country. So please do not hesitate to take the opportunity that you have during this program to ask questions. We've got the Q&A open, and feel free to put in any questions that you have. We will try to monitor them. Even though we've got this set up for 2 hours, we do have a tight agenda. And so if we don't get to a question during the Q&A session, please do follow up with any or all of the panelists after the program. Panelists, please make sure to mute everything. Mute your email and text notifications, mute your cell phones, and please mute your microphones when you are not speaking. If you are not the person designated to be the initial speaker on a particular topic, we absolutely would love to hear your voice. We would actually love to hear contrary opinions, because there are a lot of opinions on this. You know, the general rule is if you've got 2 lawyers, you'll get 3 opinions. And here we have quite a number more. And we also have a topic that really lends itself to differing opinions. So if you want to speak, we welcome it, invite it. Please just raise your hand using the reactions key, or the, I guess, raise your hand button. That'll put you right at the front of my screen, and I will call on people as I see them. Please keep your answers as concise as possible, contrary to what I just did. Also, please remember that today's program is being recorded and that the recording will be made available afterward. Our agenda for today is as follows. First, we'll briefly outline the rule, what it means, what it requires, and how it'll be enforced. We'll then give an update on the status of the various legal challenges and where they may be headed. Then we're going to highlight some of the implications of the rule taking effect if we don't have clear guidance from the courts. After that, we'll talk about strategies for complying or not complying with the rule. And then we'll end with tools that companies can use to protect their information and their relationships if non-competes wind up becoming no longer enforceable, at least for some amount of time. So those will include conventional tools as well as some new ideas. And as we move through the agenda, we have someone who will provide the initial response. And so that would be an appropriate time to ask any questions you have in the Q&A. Time permitting, we have some polls toward the end, and we'll ask everybody to respond to those, both the speakers and the audience. The responses are fully anonymous. So this really is just, these questions are designed just to get a sense of what people are thinking, whether affected by what we talk about today or not. And remember, this is a brainstorming session, so all ideas and all comments, no matter how crazy they may seem to you, are welcome, because we've got a lot of issues that we need to tackle. And I think we're going to need to be creative about them. 2 announcements. First, Eric Wybust and I, along with a handful of others who are on the call, are working on a possible amicus brief that'll be filed in the Texas action. If you're interested in signing on as an amici, please reach out to Eric, to my paralegal, Erica Hahn, and to me. You shoot an email to the 3 of us, and we will add you to the list. If you've got any questions about it, please feel free to ask any or all of us. Second, well, I guess I've already mentioned the second one, that the roundtable is being recorded. So just remember, it will be available about a week after, within the week after this. So with that, why don't we get started? And Avi, if you can give us a brief overview of what the rule says, what's banned or what's going to be banned, and what are the exceptions?
Right. So I'm sure that most of the people on this call reviewed the requirements of the rule in some detail back when it came out. But I'm going to briefly go over the requirements, both as a refresher and to set up the rest of the discussion which will get into these issues in much greater detail. The notice was published in the notice of the rule was published in the Federal Register on May 7, 2024. And the notice, I believe, said that the rule would take effect on September 4th, 2024, which would have been 120 days after publication. And so unless the rule is successfully challenged or enjoined, the effective date, I believe, will be September 4th. And I know that'll be the subject of a little bit of discussion. The rule is a modified version of the rule initially proposed by the FTC in January 2023. And the proposed rule was the subject of very extensive comment and discussion. And some of that discussion was brought forward in the supplementary materials that the FTC filed and is relevant, I believe, in interpreting where the rule ended up. The final rule was found at 16 CFR Part 910 in a new subchapter J. Section 910.1 defines non-compete clause as a term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from working for another employer or starting a business. The rule provides that with respect to workers other than senior executives, it is an unfair method of competition. And that's a key phrase given the FTC statute and what the FTC is allowed to do and what it's not allowed to do. So they define it as an unfair method of competition for a person to enter into or attempt to enter into a non-compete clause, to enforce or attempt to enforce a non-compete clause, or to represent that the worker is subject to a non-compete clause. The rule has a small carve-out for senior executives. With respect to senior executives, the rule provides that it is an unfair method of competition to enter into or attempt to enter into a non-compete clause after the effective date, or to enforce or attempt to enforce a non-compete clause that was entered into after the effective date, or to represent that the senior executive is subject to a non-compete clause where the non-compete clause was entered into after the effective date. In other words, non-compete clauses with senior executives entered into prior to the effective date are not eliminated by the rule, but as of the effective date, you can't enter into new non-compete agreements with senior executives. The definition of senior executive is very, very limited. To be a senior executive, you need to be the senior officer, president, chief executive officer, or a person who has policy-making authority. And the way the rule defines policy-making authority, it's really someone at the top of the chain within the company. The rule says specifically that that type of authority is final authority to make policy decisions for the company. If you have the authority to make policy decisions for only a subsidiary or an affiliate, that's not good enough to be defined as a senior executive. So the rule is very broad, and other than these special circumstances applicable to senior executives, the rule will apply to all workers, including full-time, part-time, independent contractors, interns, externs, volunteers, and apprentices. The FTC's 600-page supplementary information that they filed with the final rule makes it clear that forfeiture for competition agreements are prohibited by the rule. These are agreements where an employee loses a bonus or some other benefit if the employee leaves an employer and goes into competitive work. As most of us are familiar with the extensive litigation that this has engendered in Delaware. This is a complicated topic. The FTC did not see it as complicated. They didn't refer to any of the state litigation. They just said forfeiture for competition agreements are prohibited. On the other hand, while the FTC did not review and analyze every variation of the concept, the FTC did volunteer that traditional garden leave clauses would be lawful under the rule. This would be an agreement where the employee remains employed and fully compensated by the employer and subject to a duty of loyalty, but removed from and involved in the work of the employer. On the other hand, the FTC regards severance agreements where the employee is terminated and receives payments if they do not compete. The FTC regards that as unlawful under the rule, since the FTC regards this as penalizing a worker in violation of 910.1. Now, in terms of exceptions, not all industries are covered by the rule. Only those industries subject to FTC jurisdiction, which is most industries, but not all. So the rule will not cover banks, savings and loan institutions, federal credit unions, common carriers, air carriers, and certain nonprofits. Banking regulators can make a rule that apply to financial institutions, and there are other regulators of other industries, but in terms of the FTC's jurisdiction, if the FTC does not have jurisdiction over an industry, then the rule doesn't apply. This concept was confirmed in a guide that people sometimes miss. There's a document called the Noncompete Clause Rule, a guide for businesses and small entity compliance. This is a document that was prepared by the FTC staff. So it's not a document, it's not a rule that has been voted on by the FTC, but it was prepared by the FTC staff, and presumably if you comply with what's in this guide, the FTC would have a difficult time arguing that you're not complying, you're not acting in good faith, and that you haven't complied with 910.3, which has a good faith exception. So in addition, the rule applies to workers. It does not apply to business non-competes. According to the staff guide, that exclusion also excludes franchisees in relation to a franchisor. The rule does not prevent enforcement of causes of action that accrue prior to the effective date of the rule. The rule provides that the requirements of the rule do not apply where cause of action accrued, and presumably state law will govern which causes of action accrued in any given instance. One of the biggest areas of comments of the proposed rule related to NDAs and non-solicitation agreements. The major criticism of the original rule in this area was that it seemed to apply to all functional equivalents of non-competition agreements, and the formulation was vague in terms of what it applied to. In the final rule, the FTC provided some clarification, although not really a great deal of clarification. The functions to prevent criteria of section 910.1 will undoubtedly be a basis for litigation if the rule is upheld. But the FTC materials did reference some of the leading case law concerning when an NDA or other agreement might be found to be a non-compete. That's at pages 69 through 85 of the FTC comment. And, it does give you a basis to argue what's covered and what isn't. The rule does not have a carve out to protect trade secrets, but recognizes that properly scoped NDAs can be appropriate and enforceable. The supplementary information states that an NDA would not be a non-compete under 910.1, where the NDA's prohibitions on disclosure do not apply to information that arises from the worker's general training, knowledge, skill, or experience gained on the job or otherwise, and is readily ascertainable to other employees or the general public. So, again, it gives some guidance. I'm sure there'll still be plenty of litigation if the rule is upheld, in the unlikely event that the rule is upheld. As I say, it does provide some guidance. NDAs, according to the FTC, NDAs may be regarded as non-competes under the functions to prevent language when they span such a large scope of information that they function to prevent workers from seeking or accepting other work or starting a business. The FTC also clarified that while non-solicitation clauses are not necessarily barred by the rule, an overly expansive clause could potentially be viewed as a non-compete. The FTC says non-solicitation agreements are generally not non-compete clauses under the final rule because while they restrict who a worker may contact, they do not by their terms or necessarily in their effect prevent a worker from seeking or accepting other work. There again, it's ripe for litigation if the rule is upheld, but it does provide some guidance. For now, however, if the rule does take effect, appropriately scoped non-solicitation agreements, NDAs, and garden leave provisions can still be enforced, and you end up with a case-by-case determination of whether or not they come within or without the rule. And I think we're all used to case-by-case determinations. Now, in terms of where we are and why we're all on this call in the middle of August, with the September 4th deadline looming, there are major questions facing in terms of the notice that's required and the potential for implementation on September 4th.
Before you get to the notice, just a couple of things I want to make sure we just note. Number one is you mentioned that B2B agreements, franchise agreements are outside the scope of the rule, which is correct. But the FTC has also, I think, made fairly clear that don't assume that these agreements are going to be enforceable. They're just outside the scope of the rule. So don't take solace in that.
Right. Yeah, they're not giving any guarantees. They're just saying the rule doesn't apply to you.
Right. And I just want to highlight another point that you made, which is about the this functional test, which used to be called the de facto test. I think the notion that the FTC has provided any true guidance on that is a little bit overstated. I think that to your point, this is going to be a case-by-case assessment and of every agreement. And you could imagine that salespeople who have non-solicitation agreements are going to challenge those as being de facto or functional non-competes for them. Similarly, no accept agreements. So you're not going to accept business as opposed to you're not going to solicit the business. You can expect that those will be even more challenged. And some states consider those to be actual non-competes. So I think we're going to see nuances play out under the functional test as well as state by state under the functional test. So
I agree with that. And just in terms of my own thinking, I say to myself in this area that on a state by state basis, depending on state law, just if you have to draft an agreement, draft it in the least restrictive way that you possibly can and that your client will let you do in the hope that it's not going to get caught up in the rule.
Right. All right. So can you turn us to what's required under the, what's the notice requirement at this point?
Yes. So one provision of the rule that I think we all talked about at the time, but September seemed a long way off, and I have a feeling people didn't give enough credence or pay enough attention to the notice requirement until it started looming. But if there's no stay, then prior to the effective date, under the provisions, the employer, quote, must provide clear and conspicuous notice, close quote, to each covered employee that the employee's non-compete clause will not be and cannot legally be enforced against the employee. That means that by the effective date, you have to identify all the employees subject to the rule and provide notices which are individualized to a degree in the manner required by the rule, which I think for many businesses is a very large undertaking. And the specifics in the rule are found in section 910.2 B, and the notice requires that the person, and the rule defines person very broadly to include entities, corporations, etc. The person who entered into the non-compete clause with the worker must provide clear and conspicuous notice to the worker by the effective date that the worker's non-compete will not be and cannot legally be enforced against the worker. The form of the notice is also specified. The notice must identify the person who entered into the non-compete clause with the worker, be on paper delivered by hand or by mail to the worker's last known personal street address, or by email at an email address belonging to the worker, or by text message at a mobile phone belonging to the worker. So it's a serious notice, somewhat individualized. But, here again, this guide to small entities that the FTC staff puts out states in paragraph 9, the California notice, which I'm sure many here are familiar with, was an individualized notice that had to go to individual employees. The staff guide says in paragraph 9 that with respect to current workforce, and all staff email with the model language meets the requirements of the rules. And I know many people were concerned that an individually addressed letter or email was required by the rule. And this guidance from the staff is actually very helpful, because if you combine the guidance from the staff with the good faith exception under 910.3C and the safe harbor provision under 910.2B5, you could give notice, I believe, to the existing staff with an all-staff email, which would be a substantial less of a burden than the type of individualized notices that the California statute seemed to require.
Let me pause you there for a second, because I know Kate was going to talk a little bit about that, and I just want to get her perspective on both who gets the notice, when they need to get the notice, and I think with a focus on September 4 versus September 3, and then whether the notice can be modified.
Yeah, thanks, Russell, and nice to see everybody. So there's what the rule says and what we can interpret to be, and then there's a risk issue too for companies. So it's a little bit of both. So I'll get to that. In terms of in terms of the time frame, the rule says that the notice must be sent by the effective date, which is September 4th. In my view, that means that the notice should be sent by text or email or delivered by hand by 11:59 on September 4th. I don't view it as September 3rd or before the 4th, before the 4th lapse.
Before you go on,
yeah,
because I completely agree with you about that, but I have seen some people take the position that it actually, by September 4th, by the effective date, means September 3rd. Is there anybody on this call who takes that perspective and wants to fess up to it and explain why? All right. Hearing none. Go ahead.
and if it's done by mail postmarked on the 4th, that would be my view. As to the content of the notice and whether it can be modified, the rule doesn't address specifically whether it can be modified. It does have a model notice, as Avi mentioned, and it does reference a safe harbor if you use the model. But there are a number of problems, I think, with the model notice and its language. And we've talked to a number of companies about being very careful whether they use that model notice and the ability to, with risk associated with it, to modify it. All it provides, as Avi references, is to provide clear and conspicuous notice to the worker by the effective date that the worker's non-compete clause will not be and cannot legally be enforced against the worker. It's my view and my colleagues' view that that employers should be very careful using that notice. We think it misstates the law. We think it's overbroad. And given the uncertainty of what will happen with the rule, sending that notice out will result, in our view, in a revocation of contracts that will be very hard to revive. So there's a variety of options. I'm sure we've all talked about with clients and spoken about, reserving rights, referencing that the rule is being challenged, and there's not a definitive decision on that yet. As I said, that comes with risk. It may be that an employer will not be able to use the safe harbor. The FTC may argue that there hasn't been compliance. Employers need to be told of those risks, obviously, but I think those are risks worth taking given the uncertainty of where the law is going. And the other question, Russell, was who gets it?
Before you do that, I think, let me
Sure.
just check. It looks like Vicky's got her hand up. Let's see if Vicky's got a comment on this piece.
Well, I have two questions, one for Kate and one for Avi. For Kate, do you recommend alternative language?
We are recommending options to employers. One it says following the notice if they want to take no risk,
Yeah.
just follow the rules explicitly, or including a reservation, which can run the gamut of referencing the existing challenges to the rule. The fact that the Texas court has issued at least a limited injunction so far. It can run the gamut of explaining exactly what's going on, but certainly reserving the right that if the rule is found to be unconstitutional or is vacated, that the non-competes are in effect and that the employer will enforce them.
Great.
Before moving off of that one, we've got Scott and Carrie. If your questions are on this particular piece, let's start with Scott. If it is, go ahead. Otherwise, just leave your hand up.
Yeah, it's not a question, it's a comment. I was just going to add to what Kate said. And we've drafted sort of a template proposed notice for the companies that want to send notices. I think I'm with Kate, if I understood her right. I'm not even sure anybody should send notices at this point, but anyhow, aside from what Kate said, we've added, the fact that non-solicitations aren't covered, non-disclosures aren't covered, and we realize there's some gray area on the non-solicitations. We've also articulated the exceptions, including the cause of action accrual exception and some others in the draft notice. So just wanted to throw on top of that.
Great, thank you. And Carrie, I see you put your hand down if you've got something else.
I was going to make the same comment, so.
Okay, all right, thank you. So Vicky, back to you with your second question.
Yeah, I have a question for Avi. The guide seems like it could be useful. Is it limited to use by small employers, and how is that defined?
Yeah, so I mean, I haven't done a thorough research analysis in terms of the use of the guide, other than to note that the guide is drafted by the staff, so it has not been passed on by the FTC. It hasn't been passed on by the commission, but I think so. I don't know the specific answer to your question, but I do think that in an environment where you have these good faith defenses, you have the good faith defense and you have the safe harbor. Certainly, I would think you show good faith by doing what the staff says you're supposed to do. And they, of course, are the ones who would be initiating a proceeding, initiating some type of sanction against an employer who didn't act. That would come from the staff. So I think it would be difficult for them to reverse their own guide. But the guide had another provision that I wanted to bring people's attention to that relates to this point we're talking about now. Paragraph 11 basically says that paragraph 11 of the guide says that the non-competes are no longer valid. Paragraph 11 says, can I hire a worker who had a non-compete in their prior job? And the staff's answer is yes, if the prior non-compete is covered by the rule. Unless the worker was a senior executive, the prior non-compete is no longer enforceable after the rule's effective date. So, I mean, putting everything else aside, as everyone here knows, the big problem is you send these notices, an employee gets a notice that says your non-compete is no longer valid. How do you later on go back and enforce that non-compete? Let's say the employee quits and goes to your competitor and it starts working for your competitor, and the lawsuits are still wending their way through the courts. And let's say there's even a reversal. I find it difficult to believe that courts in most states will say, oh, no, you should have known that the rule was going to be set aside. So I'm going to sanction you, employee, for believing the FTC and believing the notice that you got from your employer saying that your non-compete was no longer valid, I'm going to sanction you even though you acted on that notice and took a new job. I just think it's.
I think that's fair. I mean, I think that's a legitimate concern. We're going to talk a little bit later about a little more detail about the options. So let me turn it back to Kate then for, I think the next thing you were going to cover, Kate, was about who gets the notice?
Yeah,
Cliff, can you mute yourself?
there we go. So the rule provides that the notice must be sent for each existing, and I put emphasis on existing, non-compete clause, that it's an unfair method of competition, and so on. In our view, my view, I think the modifier existing eliminates the need to send a notice to employees whose non-competes have already expired. So non-competes that are still sort of active or existing are in my view, where the notice should be sent, not ones that have been out there for a while and have expired.
Okay. And did you agree with Avi's point that you can go with a bulk email or bulk text?
Yes, I do.
Okay. If anybody disagrees with that, speak up. But thank you, Kate. And then, so Ben, you had raised a question as in the lead up to this program, asking about whether you've got to send notices to parties when they've settled a case and they've agreed upon an injunction as part of that. Can you explain the question and then answer it for us?
Yeah, I think you just explained it, Russell, and it's in the outline. In my view, if you have a settlement agreement that includes a non-compete, it's likely covered by the rule. But the question that I think is more complicated is if you, as part of settling a case, the other side agreed to an injunction and a court order was entered. We have one where a final consent judgment and injunction was entered. And my view is that I don't believe you need to give notice in that context for a couple of reasons. I mean, one is you have a court order that's already, final. And I don't know how the FTC could contend that that has somehow been vacated or somehow invalid as a result of the rule. But then you also have the existing cause of action exception under the rule that I think also would apply. So I did ask the question, but I think it's a fairly simple answer. And that might even apply in the context of a settlement agreement as well, now that I think about it. And then I do just want to jump in on the qualification issue and qualifying the notice.
Yeah.
And I tend to agree. I mean, we've got some language we've developed that basically says to the employee, look, there's a rule. It requires us to give you this notice, but there's been lawsuits that have been filed challenging the rule, and it's possible it'll ultimately be held to be invalid. And if that occurs, we consider this notice to be, of no force in effect or null and void or something like that. And so I do think I'm interested to hear what Larissa has to say about the real risk here in terms of enforcement and what companies are risking by either not sending the notice or qualifying the notice. But at least my understanding would be that
Don't give your understanding. Larissa's going to have the actual.
Okay. Yeah, that you'd have the chance to fix it, right? And if the FTC doesn't like it and your client has an issue, then maybe you have the opportunity to fix it. But I'll be curious to hear what Larissa has to say about that.
All right, we're going to keep everybody waiting for Larissa, who will be the authority on this one. But I think we have a question that I want to just make sure we get answered because it fits right within the timing here. And I think maybe Kate, you're probably the one to answer this one. The question is, there was a comment that a general email may be sent to existing employees. What about former employees who have unexpired non-competes? Must individual notices go to them, or may the general notice work for them as well?
Unexpired non-competes, did you say?
Yes.
Yeah, I would copy them. I would either or forward the notice to those folks. Just a mass email to an existing employee group is not enough for those folks. You'd have to either forward the email or send a separate email, in my view.
But you could do it as I assume you could do a BCC to
Yes.
however many group of former employees, right?
Yes, I would think that satisfies it.
Okay. And again, a reminder to all of the panelists, if you disagree with something, chime in, put your hand up. I'll call on you. We do want to get all perspectives on this because I think a lot of people are watching. A lot of people will be watching this afterward when it gets posted. And I think the advice, not advice, the information that comes out of this, I think will be useful as people try to figure out what to do. Eric Winton, you've raised your hand. Go for it.
I mean, does anyone disagree with the fact that if you're sending it by email to someone's email address, that's sufficient for the individualized attention? Like, you don't need to have an email and then under the email, dear Russell. Right? If it's going to Russell's email address, isn't that enough for individualized, even if it's the same notice that's going to everyone?
Yeah, no, I think everybody's, people chime in if you disagree, but I think everybody's of the same view that that would be sufficient, and you could do it as a bulk email. In other words, an email to all employees. You could do the entire company if you want to, and just say, to the extent that you have a non-compete, please see the attached notice or see the notice below.
And the same thing to all former employees who are within the first year of their departure. That's a restriction.
Or within the restricted period if it's
whatever
longer than the year. Yeah, exactly.
Okay.
We also got a question right before this started that I will pose and answer, because I think we've got the answer, but it's a question that might apply to a fairly large group, at least larger companies. Do foreign companies need to provide a notice to foreign, i.e. non-US workers that are party to a non-compete whose territorial restrictions include the United States? And the FTC answers that in their rule. It's at the Federal Register, volume 89, page 38367. And it says, the final rule would not invalidate non-competes entered into by foreign companies with foreign workers unless they restrict a worker's ability to work or start a business inside the US. So you can see the FTC is basically carving out anything that is entirely outside the United States. That's good of them. But the moment that it crosses the border and comes into the United States, the FTC is taking control over it and saying, the word that they used was invalid, but they've been very careful to avoid otherwise using the word invalid, and they talk about non-enforceable because they're trying to avoid retroactive effect, which I think many of us would view as nevertheless retroactive. This is just semantics. All right, so now the cliffhanger, we come to the answer. So Larissa, can you tell us, what are the consequences? What are the FTC's enforcement powers? What happens if somebody violates the rule?
Sure, yeah. Good afternoon, everyone. Happy to be here. So essentially, under the rule, and the FTC actually cites this within the rule, they have two methods by which they can go ahead and enforce violations of the rule. The first of which is under Section 5B, where the FTC would have to engage in an actual administrative procedure, go ahead and have a trial, obtain a cease and desist order. That cease and desist order would actually have to be final. So if parties were to, appeal it, there could be a delay there. And then subsequent to that, that would be the end goal. They would be instructed that they would go ahead and have to, obviously send out the notices and whatnot, but there would be no monetary penalties. And that has to do also with Section 13B, which is the second method by which the FTC could go ahead and enforce the rule, and that would be seeking a preliminary injunction or a temporary restraining order in federal court. And I think two interesting aspects of that kind of come to play. The first of which, again, no monetary penalties, as many folks here know from the Supreme Court's decision of AMG. The FTC would not be able to seek monetary penalties unless there was, in fact, an order, and that order was, in fact, violated. And we're talking about, $57,000 and change for each order's violation. So we're not talking about a significant amount of money. In addition to the fact, too, I just want to recall back a very old decision, but it was the FTC versus Shire Viropharma, where the FTC sought a preliminary injunction under 13B, but Shire had made the argument, hey, look, we're not actually engaged in the behavior in which you're coming to seek a preliminary injunction for. Can you in fact get a preliminary injunction? And so actually the Third Circuit determined that if the behavior is not occurring or is not likely to occur, then there's really no authority for the FTC to get a preliminary injunction under 13B. So arguably, if you are not following the rule and September 4th comes and goes, and for some reason, then the FTC, you think that the FTC is actually going to start enforcing this, or they catch wind of what you're doing. And I'm not necessarily suggesting folks do this, but since we are kind of interested in how likely is it that the FTC is going to come after these folks, If you were to engage in all the behaviors that are necessary under the rule, sending notice, et cetera, and you're not enforcing at the time a non-compete, then it would be hard for them to go after you under 13B based on Shire. Now, the facts of Shire were it was pretty significant. It was over a very long period of time, and the company had changed hands, et cetera. So there may be some disparate facts, but arguably one could say that the FTC could not actually enforce under 13B and get that preliminary injunction. So they'd have to go the 5B route.
Right. So,
And I think I was going to say, just in terms of Ben's question too, in terms of, say you don't send the notice, et cetera. I mean, one thing that I would advocate for folks to take a look at is the FTC's policy statement on Section 5, particularly with unfair methods of competition. And the FTC was very clear there that they don't believe that there actually has to be a harm that happens. There could just be the likelihood of harm. And so failure to send those notices, even if you're not enforcing them, arguably, I think that they would at least argue, could be a likelihood of harm, because folks may not be acting on seeking employment elsewhere because they think that the non-compete is actually still enforceable. So, something to kind of keep in mind there as well.
great. Thank you.
Russell, can I ask a quick qualification on that?
Please.
Of Larissa. So Larissa, just to be
Sure.
clear then, whether it's under Section 5B or 13B, the FTC is going to do something, and you have the opportunity to just enter into a consent order that says, okay, we'll send the notice, right?
Sure. Yeah, no, absolutely. I mean, there's still the PR, the investigation, and
Sure.
the potential trial lead up that a lot of folks, I think, arguably don't want to, engage in. But then, yeah, if there is a violation, say you do forget to send a notice to one of the employees, et cetera, if the FTC really wanted to go after you, that's when they would be able to seek monetary penalties after the fact, once that order is in place.
Right.
Thank you.
And remember
Yeah.
that the FTC did that. They did these consent orders with a handful of companies that they announced on January 4th, and then used to say, look at all the stuff that we've been doing, when they announced their proposed rule the next day. So thank you, Larissa. I think, Avi, you've got a question, and then we'll go to Kate.
Yeah, so, we're talking mostly about the notice, but let's say on September 5th, you hire a new employee and you ask the new employee to sign a non-compete. Something tells me that the FTC might take a different attitude toward a company that was continuing to get new employees or old employees to sign non-competes, as opposed to someone who just didn't send the notice. So what do you see as the risk for that situation?
I'm going to ask Larissa, and then I'm going to ask Eric Winton if he cares to comment on that one.
Sure. So I just want to make sure I understand the hypothetical. So the employer has sent out all the requisite notices, but then after the fact, still puts someone under a non-compete who arguably doesn't fall
No.
under one of the exceptions?
No, the employer doesn't send out the notices. The employer says, this rule is going to get set aside in 3 months. I'm not going to comply. I'm not sending out the notice. Plus, I continue to hire people. And, when I hire a salesperson, I'm going to have them sign a non-compete, not just a non-solicit. Or if I hire an executive, let's make an executive who will not qualify as a senior executive, I'm going to ask them to hire to sign a non-compete so that they can't go to my competitor.
Yeah, no, I mean, I think obviously all of that would fall under a potential violation under the rule, right? Unless they were to go ahead and course correct. And I think too, the FTC, just the point that I was making before under 13B, likely that they are in fact engaged in the violation or likely to engage. I think the FTC would use that as, perhaps implicit evidence that they're likely to continue the behavior because they're still doing it after the date in which, the rule came into effect.
Right, and I would assume the FTC would take less kindly to an employer who continues to sign non-competes or continues to tell new hires that they need to sign non-competes than to employers who just don't send out the notice.
Agreed. But Eric, let me just turn to you. You don't have to answer if you don't want to, but I know you and I have spoken about this issue before. Do you want to address that?
Yeah, I mean, look, of the 3 requirements, right? There's notice, there's don't enforce, and there's don't have people sign new ones. I think the middle one there, like that's the one that the FTC you would think would draw their most ire if you're continuing to try to enforce these things after the effective date, if there's lack of clarity. I think the notice, I mean, clients are asking, hey, what if the notice is a few days late? I mean, is that really going to be a big deal, right? I doubt the FTC is going after them for that. If people are signing new agreements, that still have non-competes in them. I mean, I think this is on the outline somewhere. If they're signing what we want, Russell and I have been throwing about, whether you call it Russell's springing non-compete or an exploding non-compete like Mission Impossible, this will self-destruct, right? If the FTC rule goes forward. I mean, maybe that's the middle ground that you could have where they sign something going forward with some kind of caveat that this doesn't go into effect unless the rule is invalidated, or if the rule goes forward, it explodes.
All right. Kate, have you got a?
Yeah, just a quick question, and maybe this is a rabbit hole we don't need to go down to, it might not be relevant, but I've had a number of clients talk about the sort of the mini or little FTC acts in various states across the country. And, we've seen a little activity from the FTC, for example, reaching out to the governor of Maine saying, oh, you better not veto this or else. There seems to be a little more, and this is not my area, this part of the law, but it seems like there's a little more risk under those types of acts, maybe not in Massachusetts where I am, it's because the remedies are broader. So I don't know if you've given that any thought, or anybody else on the phone has thought about that versus sort of the typical FTC enforcement action.
I have, but I'm going to look at Larissa because I see her nodding her head and she is the expert here. So go ahead, Larissa.
I think it's a great point. And there are at least like 24 states that have these little mini FTC acts that are supposed to be basically part and parcel the exact same thing. And there is case precedent in a lot of these states that indicate that they interpret federal law, that they use federal law interpretation as to how they're going to go ahead and act on it from a state perspective. And they do sometimes provide not only for the AG to bring enforcement, but for private plaintiffs to bring enforcement and also to seek monetary damages. And so I think what'll really kind of come down to, right, is what happens in the Northern District of Texas in addition to what happens in the Eastern District of Pennsylvania. Because if they are trying to interpret federal law and it's vacated, for instance, full throttle in the Northern District of Texas for everyone, not necessarily just for the entities that actually brought the suit, which I think kind of made everybody scratch their heads a little bit after that PI was first issued, then one could point to that, even no matter what the Eastern District of Pennsylvania does and says, well, look, that's not actually federal law because that trumps. What may be more difficult is if Northern District of Texas says it's only for the parties who filed, and then the Eastern District of Pennsylvania matters up there. And then you start getting into this, like, do you want to argue, arbitrary and capricious, try to bring it into federal court, stay the state proceeding, all that sort of stuff, which I don't think anyone necessarily wants to get into. But presuming that the Northern District of Texas, follows through, I think folks can get at least a little bit of comfort that the ability for someone to try to interpret the federal law as part of the mini, as how to look at the mini FTC acts, I think it's gonna be a little bit more difficult. So I think there is some comfort there.
Okay, thank you.
That was it.
Yep.
Scott?
Yeah, I just want to add that we're talking, about the Texas case, the Pennsylvania case, and of course there's one down in Florida. But, I bet you 2 weeks before the September 4 or a week before, we're talking about 10 or 15 more lawsuits with TROs pending and all of that. I know that's coming later, but I just want to point out that the FTC is about to have its hands really full. And I just don't think that I could be totally wrong. And other people on this call know a lot more about the FTC than I do, but I feel like it's going to have bigger fish to fry than chasing around folks who haven't done a notice yet.
I agree. The FTC, right, was before Congress a couple of weeks ago saying that they needed more money, right. So, and I don't know how receptive Congress was, but yeah, how that goes. All right. Well, Larissa, anything else on this piece, the private right of action piece, or anything else?
The only thing that I would add is, I completely agree. It's sort of like, when are they going to start? How would they start enforcement? Where would that kind of come? And I think a question would be, are folks going to file individual complaints to the FTC, which would also flood them, albeit in a different way? And, are they going to target certain industries more than others? Unclear. But I would, I think that they're going to have, again, I agree with you, their hands full for a while until you actually see an enforcement action move ahead. I think they also, though, may use their subpoena power in terms of whether it's for a merger and acquisition or whether it's a civil investigative demand on something completely unrelated, to try to gather evidence as well related to this and kind of bring a tangential investigation, because we've already seen them do that in some other spaces, including, for instance, interlocking directorates. The FTC and the DOJ have been focused on board members being across the spectrum from, one competitor to the other, and they've used CIDs and merger, HSR related second requests to kind of get that information as well. So I think they do have a couple tools in the tool belt to get this information if they really wanted it.
Thank you, Larissa. All right, so we're going to turn to the status of the cases, and we've got Lauren Schaefer and John Siegel. So let me ask Lauren, can you give us just what current cases are, what the timing is, what the expectations are? And I'm going to try to move these all along a little bit faster because I know that we've spent a lot of time with really good discussion, but I do want to make sure that we have ample time at the end to talk about kind of the things that companies should be thinking about doing. So not to keep it brief, but keep it brief.
I will keep it brief. And I will address the three cases that have been touched on here, and I'm going to go in order that they were filed. So the first case is Ryan LLC versus FTC. That's the case that was referenced as pending in the Northern District of Texas. It was filed on the same day that the FTC announced the adoption of its final rule, so it was the first one to file. They're arguing Ryan LLC is a global tax services firm. They're arguing that the FTC does not have authority to issue the rule. And on May 1st, so approximately a week after they filed the complaint, they moved for to stay the effective date of the rule and for a preliminary injunction. And soon after that, the U.S. Chamber of Commerce intervened in that case. The U.S. Chamber of Commerce had filed its own case, but also in federal court in Texas, but was politely requested to intervene in the Ryan LLC case instead for issues of comity. So a little bit embarrassing, I think, for the U.S. Chamber of Commerce to not be the first to file here. But in connection with the pending motion to stay, there was a flurry of amicus briefs. We've seen that in all of the cases that are pending right now on both sides. And on July 3rd, Judge Ada Brown issued her opinion on the motion for preliminary injunction. She granted it, but limited the scope of the injunction to the named plaintiffs. And following that injunction, the U.S. Chamber of Commerce filed a request for her to reconsider and to expand the scope because of the confusion, obviously, that comes from an opinion that is limited only to the parties to the case, and the court declined to do so. So the current status is that there is an injunction out of the Northern District of Texas, but it applies only to the named parties in that case. Currently, the parties in that case are in the process of briefing summary judgment. So the Ryan LLC filed their motion for summary judgment on the 19th of July. An opposition was filed on the 2nd of August, and we're waiting for a reply. And the court has indicated that it'll issue its final ruling before August 30th. The parties are actually moving faster than the scheduling order in the case in terms of getting the papers on file. So I don't know, but I'm crossing my fingers that hopefully the court will also move faster and we'll have an opinion on that one sooner than 4 days before the final rule goes into effect. So we will see. The second case filed was ATS Tree Services versus FTC. That one was filed on April 25th in the Eastern District of Pennsylvania. An interesting plaintiff because it's a tree services company with only 12 employees, so not necessarily who I think we would have expected to be one of the key cases that we're watching here, but nevertheless, same issues. They're challenging the FTC's authority to issue the rule. There was a hearing on their motion for preliminary injunction on July 10th, and coming out of that hearing, I think people were somewhat optimistic that the court could potentially be inclined to issue an injunction, but unfortunately they did not. So the court issued its ruling on July 23rd and declined to issue a preliminary injunction, saying in part that there was no irreparable harm, but also despite the fact that they found there was no irreparable harm and could have stopped the analysis there, also reaching to say that there was no likelihood of success on the merits because the FTC, in fact, did have authority to issue the rule. So it did go so far as to say that. So we now obviously have some competing opinions out of the two different federal courts. And then on June 21st, so significantly later than the other litigations, in the Middle District of Florida, Properties of the Villages versus FTC was filed. Once again, the plaintiff in that case has moved for a preliminary injunction, but critically their papers request relief that's limited only to the named parties in the case. So I don't think anybody is watching that case hoping for a nationwide injunction that's going to create certainty for everybody and put all of our minds at ease. But there's a hearing in that case on August 14th, so certainly still one to watch.
Great, thank you. And Sarah Ratner, you have your hand up. All right. Thank you, Lauren. John, you want to tell us about any other cases or any likely cases?
No, not exactly. But I want to give a few comments. Lauren gave a very thorough rundown.
Yeah.
The Villages case, which our firm is one of the plaintiffs' counsel, along with Covington and Burling, and my partners Meg Martin and Pat Muldowney are involved in that and do work regularly for the Villages. One distinction between that case and the others that may have some significance is the Villages has previously obtained injunctive relief under their non-compete. There was a bench trial several years ago. The Villages got an 18-month injunction, an order requiring return of all customer lists plus damages in the same district, not the same judge, same district. But in terms of the necessity, the impact of not enjoining the rule and sort of a rule of reason analysis, that kind of distinguishes that case, I think, from the others. Second comment I wanted to make, not that I'm pandering to all the people on this call who do non-compete litigation for a living, but it struck me reading these decisions, especially the ATS case and the oral argument there, that the district judge looked at what district judges and trial court judges look at on injunction applications all of the time. Tell me how you're going to be irreparably injured if I don't do this. And that should come not as not the furthest thing from a surprise to all of us. But if you read the complaints filed in these cases, the complaint in the Ryan case, frankly, I've never seen a complaint that mostly cites law review articles and was clearly written for some other court, put it that way. And these cases are being decided in trial courts by judges who have to assess irreparable injury. And that's gotten lost in the mix somewhere here to the detriment, I think, of the plaintiffs. Third comment I wanted to make is on the issue of nationwide scope and nationwide injunction. There's a paradox here. The status quo is a lack of uniformity in the law. And that lack of uniformity in the law and the fact that it differs state by state is an argument that many of us have made, and Russell, I think you made in your submission to the FTC, as a reason not to adopt this rule. Let the laboratories of democracy continue to experiment at the state level. So there's certainly a paradox then to say, well, the FTC rule should be enjoined when the law on nationwide injunctions is in situations where uniformity is required. And that's what the Ryan court pointed to, was an immigration case, saying that immigration law as a national matter needs to be uniform, and distinguished this from a national immigration system. And so I think that's an issue here, and a problem is that, and will become more so if the rule goes into effect at in some way, because then it would become really a request for a mandatory injunction, changing the status quo. So I think those are some issues that I just wanted to highlight on this. The question I wanted to raise for the group is this: if, as seems, I don't predict litigation because I do it for a living, if on September 4th, there are competing district court decisions, none purporting to be a nationwide injunction, and the rule takes effect, what will the impact of that be, not in litigations brought against the FTC challenging the rule, but in the garden variety cases that we all do every day in state and federal courts across the country? I mean, won't the rule be cited as a defense
I think you,
by any company that's trying to avoid the impact of a non-compete, or any employer someone's trying to hold to it and they want to escape it? I mean, it seems to me at that point, there'll be just an enormous proliferation of rulings in all sorts of contexts. So I was wondering, does anyone think that won't happen, or how will that play out? And those are the issues I wanted to highlight, Russell.
all right. Well, thank you, John. I appreciate that. And Scott, we're going to come back to you because I know Eric Wint and John Barry, both were going to address John's question, John Siegel's question.
I didn't know that, but
yeah.
you've got really good answers.
No, listen, we've got people lined up for every question that can be asked here.
That was great handing off of the baton, John. That was right within the outline. What's going to happen? Because that's what what I wanted to speak about, which is what sort of the practical effect that's going to happen on September 4th, when we what looks like lack of clarity on that date. That's what we're all leaning towards, right? So lack of clarity on that date. I think there's going to be a whole lot of employee movement, right? I mean, there are a lot of aggressive employers out there who have been waiting to hire talent, and there are a lot of employees out there who have been staying because they think they're bound by restrictive covenants. So if they think, if they're going to be reading the newspapers, which they are, or hearing the media reports, or online, CNN, whatever they're finding their news, they know that this is going to be in effect, or at least lack of clarity on that issue. So they're going to feel like they can go, and new employers are going to feel like they can take them. So it's going to be what I think there's going to be sort of a glut of movement at the same time. Some companies, as we've already discussed today, are going to be concerned about trying to enforce non-competes after September 4th, when there's lack of clarity as to the rule, in concern that might be, sort of the worst version of a violation of the rule, and I might incur the ire of the FTC, even if that ire doesn't have much teeth in it, at least initially. So you're going to have a bunch of people leaving, and what I thought is going to be interesting about it is, I don't think a lot of the employees who are going to think they're free and clear out of a non-compete are going to understand the nuances between I'm free and clear from my non-compete, as opposed to I'm not free and clear from my duties of loyalty and my obligations under employee customer non-solicitation and non-disclosure. So they may think, hey, I can go to a competitor now. That may also mean I can go whisper to my coworker, why don't you come with me? Or I may talk to my customers, why don't you come with me, or take information. So I think for employers on both sides of this equation, whether you're going to be aggressively hiring new talent, you've been waiting for this, be careful about what your potential new hires are doing and how involved you are in that recruitment. And then for employers losing employees right after September 4th, it's not hopeless. You have other potential avenues to go after people who are going to be sloppy and not just cleanly leave because they're not bound by non-compete any longer, but start whispering in people's ears while they're still working for you, breach their employee non-solicit, breach their customer non-solicit, and take information with them. And one last piece about this, which is sort of the second big piece of irony in all this, right? The first big piece is that there's an injunction right now against the FTC, and then FTC is looking for a rule getting rid of the ability to get an injunction for a non-compete, right? So that's the irony number one. Irony number two is that one of the reasons behind this rule is to combat what the studies say about limiting wage increases. But if you're going to have a glut of people on September 4th at the same time looking for jobs, they're not going to have much bargaining power, right? Because new hiring companies are going to be like, well, if I don't hire that guy, I'm going to hire the next guy. Why do I have to offer more money? So at least initially, when there's so many people in the hiring pot, I'm not sure it's going to benefit that aspect of the rule that they were looking for to combat wage stagnation.
Well, I think that point, just that last point, and then I'm going to go to John Barry and then Eric Weibust. But that last point is instructive. Evan Starr and some others did a study on the impacts of, I think it was was either Washington and Oregon's wage, it was Washington's wage threshold, I think, and looked to see whether right around the threshold, if people got a bump in compensation, so that the way they interpreted it, if there was not a bump in compensation, then companies didn't value non-competes. I think, maybe it signifies maybe that companies didn't value non-competes for people at that level because they didn't need them for people at that level. Maybe it also reflects what you're talking about, Eric, which is suddenly there are more people available on the market. Now, the problem with that was the rule had this weird retroactive impact. So it's a question about how it would wind up being enforced and whether we'd really see that outcome. Anyway, all that to say, the studies and the wage impacts that they purport to identify are not necessarily reliable. I think there are lots of problems with them. We can spend hours talking about those studies. I could spend hours talking about those studies. I won't. So let me turn it over to John Barry, if you had anything else to add there, and then we'll turn to Eric Wybust. Thank you, Eric Winton.
Yeah, thanks, Russell. So I think we all recognize that after September 4th, there'll be very interesting cases that come out where there'll be some great arguments that we can use and rely upon. Some of the things that Lauren spoke about that were the preliminary findings down in Texas about the FTC's authority. And that'll be helpful. That'll make some good cases. But realistically, there's going to be a lot of judges who don't do much analysis. And there will be judges who just say that I can't enforce a non-compete because I have this FTC rule sitting out there. They're not going to take the time to dig into it. So there's a big concern with how that's going to play out, because some judges in issuing these decisions might be conflating when they make the decision that this is under state law. Say, like, for example, if think of any of the big jurisdictions, whether it's in Boston, it's in New York, elsewhere around the country, major metropolitan areas, saying suddenly under New York law, I am deciding that non-competes are not enforceable. Now, thinking ahead to the future, when this rule goes away, what are we left with? Are we left with a circumstance where judges have ruled that non-competes are no longer enforceable under New York law? Or do we have something different? And there's going to be, I think, a lot of issues and a lot of problems and a lot of judges going back and forth on this until a higher court actually weighs in and hopefully says that was all an aberration. It was all under the FTC rule. It wasn't under state law. And we need to kind of get back to this place. But I just flagged that, I know the people on this, in this panel who argue this all the time. This is going to be, I think, an important issue to try to remind judges about if they're inclined to go in a certain direction, that we try to make clear that these are decisions under the FTC's rule. And this is not something that they're saying would apply under the state law, but it's going to create some really, I think we can say interesting issues, but some very problematic issues, for companies trying to figure out how to do this, and also they want to be able to unwind, some of these things that they're going to be doing when this rule goes into effect. So that's just my only comments. Thanks, Russell.
Yeah, no, I think that's great. I agree. It's a very good point. Eric.
Yeah, and I apologize. I was a few minutes late, so if you already covered this, just tell me to shut up. But I agree with everything John just said about what judges will do in affirmative, trying to enforce a non-compete. I'm not as concerned though about there being a lack of clarity after the 30th, because the relief the plaintiffs are seeking is vacatur, and the injunction stage is over. I suppose the court could issue a permanent type injunction. Larissa will correct me if I'm wrong, but my understanding is that in the Fifth Circuit jurisprudence, at least, that has national universal effect. The rule is just vacated for everybody. It's not vacated just for the parties. It's not vacated just for the parties and their members. It's vacated for everybody. You may have academics out there arguing otherwise. You'll certainly have litigants out there arguing otherwise. But as I understand it, the state of the law is once it's vacated till an appeals court or Supreme Court says otherwise.
Great.
Yeah, no, I agree with that. And I think there was just recently a decision, right? It was like Texas Medical Association that just had that same holding. So I think you're absolutely right, particularly in that jurisdiction.
Right. And I mean, logically, it certainly makes sense. but when has logic ever affected the law? All right, strategies for complying with or otherwise responding to the rules. So we've got a few people who are going to cover these. Let me start with Scott McLaughlin and talk about what it looks like to comply with the notice requirement with no changes. I know we talked a little bit about that already, but maybe you could talk about that and then take us into the conditions and what they might look like.
Well, okay, I was going to say, I think that topic's been covered thoroughly early, complying with the notice with no changes. Yep. And of course, if you do that, you've just agreed to waive your non-competes for, some of us would say, no good reason. And that seems like a big step. Mm-hmm. Did you say I should also talk about conditions or no? Russell?
Yeah, you should talk about conditions. I just want to ask you though, just on the notice, do you need to include, do you recommend including it to the extent that somebody wants to send a notice? I get that you suggest maybe they not do that, but
I'm in Texas. We're not sending notices.
That's Texas, right? But to the extent that somebody's outside of Texas, say in Pennsylvania, or in the Third Circuit, and they are looking to send a notice, is it permissible to, or should they say, look, the notice covers these things, it doesn't cover senior executives, for example, who already have not.
Yeah, that's what I was going to talk about. My personal view is that the FTC will frown upon that practice, but I'm guessing. I did notice in the handy guide that Ari, I think, referenced earlier. So I was actually unaware of that. I pulled it up and was reading it while he was talking, and it says a nice, I'm going to read it, really happy little phrase here that says, model language for the notice can be found here. This is step 2 of compliance. If you prefer, you can write your own notice. So I think we'll take them up on that. Write our own notice. And, the notices we're looking at for clients are, articulating the idea that non-solicits are not covered, understanding that's debatable within the FTC. Non-disclosures are not covered. Again, understanding that the FTC could.
Let me ask you, Scott, just in terms of what you're putting in the notices so that people have the benefit of that. Are you saying that non-disclosure agreements and non-solicitation agreements are never covered? Or are you saying that in most instances, are you qualifying it in some way?
I'd have to look at our language. I don't think we qualified it. I think we said that the rule applies to non-competes. The rule does not apply to no solicits. Again, we understand how gray that is. Yeah. But we're going to try to preserve rights. If a client wants to send a notice, we're going to try to preserve rights. And in particular, the notice some clients are sending is basically saying this notice is only effective if the rule remains effective. If the rule fails, the non-competes have never been, withdrawn, voided, and we will continue to enforce them. So it's kind of cake and eat it too. I don't think there's much chance, and I think Larissa would certainly know better than me, among others, but I don't think there's much chance the FTC would view that as a compliant notice. It's not willing to contemplate the failure of its rule, I expect. And so we with what we give these clients, we're listing bullet points. FTC is not going to like this, so don't consider it a safe harbor. But these are for clients who refuse to send the notices drafted and are adamant about protecting rights, but trying to do something. Personally, I think doing nothing is probably not a lot worse than sending the notice I'm talking about in the FTC's eyes. I mean, I don't know. I wonder. I'd solicit others' thoughts on that.
Okay. Carrie, you've got a question or comment?
Yeah, I was just going to ask Scott. I mean, what I've been recommending is literally telling people in the notice, if they're sending it, that it's this paragraph of the agreement or this subparagraph of the agreement that isn't enforceable, versus just labeling things non-solicit confidentiality to avoid any doubt. Meaning, to the extent you're attempting to say you've complied, do you want to limit it to whatever provision of this specific agreement has the non-compete language in it?
That's a great idea. I think that's a lot more solid than just calling things non-competes and non-solicits. We're drafting in a sense for clients who actually have multiple types of agreements. And I don't know that we can precisely do that, but every time somebody can, that's a better practice than what I described.
That's what I've been trying to advise people on, to the extent we're doing tailored notices, if you will.
Right.
Thank you. Eric Winton, before come back.
I know you're running a tight ship here, Russell, but I just want to go back a second because I had to process it from one Eric W. in Boston to the other Eric W. in Boston. So Wybus, you just said that you don't think there's going to be a lack of clarity. So just talk me through, if the Texas court does that, what happens to the case in Philadelphia?
I don't know what happens to the case in Philadelphia. I'd hope they would drop it, but my understanding is that the rule is just invalid. It doesn't matter what happens there.
Well, won't the FTC do something? I mean, you don't think
The
they'll try to
FTC
do
does a lot
something?
of stuff.
What's that?
Yeah, of course the FTC will take that position. They do a lot of stuff that's illegal,
No,
but
I understand. So that's where I'm coming from, a lack of
Yeah.
clarity. The Third Circuit, they'll try to do something to address
Hold
that.
on, Vicky's got her hand up, which means we have an answer. Go
Great,
ahead.
that's even better.
No, now she's saying no. No, Vicky, something else?
No answer, just a question. I had thought that the Texas court had said that its ruling would be confined to the plaintiff and the members of the Chamber of Commerce.
No, not the members. Not yet. It's just
So
the
I'm wondering why we're thinking Fifth Circuit law that's been applied in other cases to make nationwide injunctions would be applicable.
I can answer that, Russell, because
yeah, go ahead, Eric. Go ahead.
Because we're not at the injunction stage anymore. What the Texas court did was say, I'm not going to issue a nationwide injunction. I'm going to limit the injunction solely to the parties, not even to the associational members. But now that we've moved on to the merits ruling, the court's not indicated anything about how they're going to rule. And if they vacate, which is what the plaintiffs have asked for, that would have national effect. And the FTC may take a different position, but I don't. And state court judges, as John was saying, may take different positions if you're trying to enforce it, especially when they're balancing the equities and whatnot. But as far as I know, the rule would just be vacated until an appeals court said otherwise. But that's the extent of my knowledge.
Winton, you done? Yeah, you're muted.
Sorry, I guess it would just be the FTC at the third might appeal to the Third Circuit to try to fight that. And then we're looking at just going down the same road of the circuit split that we think we might have. But I guess we'll find out when we do.
All right, thank you. And Kate, we're going to talk to you in a sec. We're going to turn to you in a second. I know Larissa's got her hand up, which means here we have the answer. Go ahead, Larissa.
No, well, I guess the one thing that I would add is that even if, there's a question as to the applicability of the rule, or we have a circuit split or something like that, and say we all agree that if the Fifth Circuit were to go ahead and say it applies to everyone, that doesn't preclude the FTC from bringing cases under the current antitrust laws to say that more should be found to be anti-competitive than what current jurisprudence actually says. And that would actually combat then some of the arguments that are being made under the APA that the FTC doesn't have the experience or the knowledge or the understanding of the actual industry in order to draft the rule as currently written. So there's still arguably the chance that they're going to try to bring cases to make it more and more likely that non-competes are going to be anti-competitive. Now, whether they're successful, it's a whole other ballgame, but that doesn't preclude them from actually doing it. So I just want to make sure everybody's got that sort of background on that.
Very important. Thank you. Kate, I think you had your hand up.
Yeah, I was just going to say that I'm agreeing with Eric Weibust about the vacating the rule, but there is some Supreme Court commentary from 3 of the Republican sitting justices that are not fans of vacating an agency rule. So I think it would end up there and be an interesting discussion from the Supreme Court view. They're sort of anti this type of action, perhaps, but not fans of vacating rules. So it'd be interesting to see how it plays out if it gets that far, which it likely will.
Yeah. Thank you. All right. So we do have a question. Then Scott, we're coming back to you for any wrapping up on that compliance piece. The question is for anybody who wants to answer it. I think probably Scott, you're first up if you want to. Do you think that the notices should have some sentence saying that if the FTC rule ultimately ends up being overturned, for example, it goes up to the Supreme Court, then the company will enforce non-competes at least from and after that date?
Yeah, I think the way sort of our work in progress reads is that if the rule fails or if the rule's invalid, the non-competes remained effective and we will enforce them. If the rule, this vacating of the rule is an interesting concept, but I can't say I'd thought through. And it sounds like maybe there's an argument that the rule fails on August 30th if the judge rules, as she has said. That may affect how we're going to draft aggressive templates, basically, is what I'm saying. And we're going to try to protect our clients' ability to maintain the enforceability of their non-competes basically until the Supreme Court says we can't, I think, the way things are going, right? I mean, if we had a bunch of cases out there enforcing the rule, we would not be so strident in my practice group, but that's not the way we see the tea leaves going. And so we're going to try to protect the contracts, and we're going to try to be, you know, reasonably aggressive about that. So yes, basically.
Great. Well, let me just ask you then, I'm going to jump a little bit ahead in our outline for the panelists who are following along. On the risks of ignoring, I think we've covered a lot of that, the good faith exception. I think, Kate, if you've got anything to add on that piece, yeah, obviously you're shaking your head. I think we've covered that as well. Scott, you want to just address the effect of being a member of the chamber? I know we kind of glossed over that piece. I think it's probably worth just clarifying for people who are following along.
Yeah, I'm not sure I'm the right person to clarify because I can't figure out whether there's a ton of benefit under the current preliminary injunction.
Right, none under the current.
Limited, right? Yeah. So the question is, and I don't know procedurally if the Fifth Circuit has the power to expand an injunction to make it national instead of, in other words, grow the injunction that Judge Brown granted. I think maybe it does, but I'm no appellate specialist.
No, I think the way this would play out is between now and when the judge issues her order on August 30th, which we're expecting will be broader than what she did on the preliminary injunction, because that was, as we discussed, that was preliminary. We're now going to get a final ruling. And so the expectation is that the final ruling, she may do a number of different things. Anything, I mean, in theory, she could reverse herself. I don't think she'll do that. But assuming that she issues some sort of an injunction, she could do exactly what she's already done. But she may expand it to include all the members of the organizations before her. So the question becomes then, well, should people quickly, if they're not members already, join and be right?
Yeah, and I just was going to say, a client asked me that today.
Yeah,
and on going through all this, and my response was the same as Kate's. I said, well, I can't see how it hurts, and it's great for the chamber's business, right? You talk about great advertising for the chamber. Join now and get protection before August 30th.
Right. And then there would be questions about whether you needed to be a member at the beginning of the case.
We had that discussion too. And
I think there's a business roundtable too, is one of the.
Yeah, there is.
That's another
There's
option.
also, Russell, been some companies and organizations that have moved to intervene in that case.
That was my next question.
Yeah.
John, that was the next question. I think Eric Packel, were you going to talk about that?
Yeah, I thought I was pretty clear on all of this until the last hour and a half. So yeah, 4 parties intervened in the Ryan case: the U.S. Chamber, Business Roundtable, Texas Association of Business, and Longview Chamber of Commerce. And I don't know, Russell, if you were talking about intervening or on that part of it.
Yeah,
I'm with Eric Wybus that's been our understanding. We've really been waiting for August 30th to see what happened with that court. And if the rule is vacated, relying upon that. So in terms of intervening, you could permissively intervene in one of these cases, but I think that ship has largely sailed because only those 4 parties intervened in the Ryan case. But that's an option that parties could take. But for right now, it's only 3 weeks away. That we wait and see what this Ryan judge does and how that affects the landscape.
Yep. And so, go ahead, Jim Witz.
Hey, I just was wondering, following up on Eric Wybus' comments, is there a mechanism? Because I've talked to some people who know this judge who were skeptical that she would expand the scope of her initial ruling. And I'm wondering, is there a methodology under the current briefing, other than just purely vacating the rule, where she could come to some kind of more limited ruling where she expressly doesn't want to have a nationwide impact and could kind of limit the scope of her ruling? I'm just curious if anybody's aware of, is there any mechanism, or do we really think that there's going to be a vacatur of the rule that is going to have this, nationwide impact, or is there some other mechanism that we think she could use? Because I've talked to people who say that she would probably tend to be a little bit more conservative than issuing that sort of, nationwide, a ruling with that kind of nationwide impact.
People have
Anybody
thoughts
have
on
any
that?
insight into that?
I think the APA says you have to vacate, and I don't see it as the nationwide effect is one thing, and there's the debate going on, as Kate probably said, between the justices and concurrent opinions. about whether that's right or not, but that's not going to be resolved before the 30th. So the only issue she has to decide is whether to vacate or not. I think the APA says she has to if she finds that they've exceeded their authority and it's arbitrary and capricious, which she's already preliminarily found. And she shouldn't worry herself with whether that's nationwide. I suppose she could do something lesser, like issue some sort of permanent injunction, I guess, without vacating it. I don't know how that would play out. But if she vacates, you can't like do a partial vacatur, I don't think.
Well, but there's a lot of options. It's a summary judgment motion. She can find that there are issues of fact as to certain implementation issues or effectiveness issues. There's a lot of ways she could slice and dice this.
Yeah, she could deny it. Yeah.
Yeah, or without denying it altogether, she could vacate and hold a hearing as to what the effect should be or how it should be done. There's just a lot of things it seems to me she could do.
All right. Any contrary opinions? All right. So then let's just turn to any other options before we turn to kind of how companies should be thinking about their agreements moving forward and other steps that they might want to take in our last half hour. Are there any other options for complying or malicious compliance or challenging through a separate lawsuit that anybody wants to cover? Kate?
So I think, I think there was a reference earlier on that there might be, dozens of other lawsuits filed, and that may very well be. And they're all going to be behind the current ones, so I'm not sure how helpful that'll be, other than maybe in the different district. And I think, there's also, we've talked with clients about the concern that you put a target on your back by filing these lawsuits. So there are some organizations that I know that I really can't say who, but are thinking about filing lawsuits right now that companies could support and sort of financially support and stand behind, but not put their names on it as well, similar to what the chamber has done. So I'm not sure the effectiveness of single lawsuits and getting you to a definitive decision anytime sooner. But I'd love to hear what other people think.
Well, it looks like Scott's got a view. Go ahead, Scott.
Yeah, I think what I'd say about being behind, of course, that's right chronologically, but if you filed a week before September 4, and you seek a TRO and a national one, and you're in the right court, what happens? Do you leapfrog, Judge Brown in the Northern District, particularly if she tries to do something ambiguous on vacatur? So I think that I think there may be some opportunities there, but it's anything but certain. And B, my own feeling, I think that of our group is that the more heat on the FTC right now, more lawsuits, the more TRO requests, what have you, the better for those of us who oppose the notion of this rule, rather than just having 3 lawsuits out there, 2 of which frankly are kind of, the Villages, I think, is in a unique situation down in Florida. The tree service case, as I think somebody said earlier, although whoever said it was much more diplomatic than me, is really hard to take seriously.
Right. And make them work harder. I did notice they were advertising for new lawyers at the FTC.
I'm keeping my day job.
All right. Well, thank you. Let's turn then to what the alternatives will be in a world without non-competes, because remember that it's not just the FTC rule, but there's also states that are looking at banning non-competes. I mean, so far, every governor that's been presented with a non-compete ban, there have been 4. 3 of them have rejected them. Only Governor Walz, this is not a political comment, Governor Walz has signed a non-compete ban that was last year, went into effect in July of 2023. But every other state has rejected them. But that it may change, right? There is momentum that at least the media would have people think exists, and the FTC would have people think exists. So we'll see what winds up happening. But I think the other place we need to be focused is in Congress, because although obviously there have been bills pending in Congress since 2015, again, there's this feeling of momentum, and it may be that Congress steps in and winds up doing something with regard to non-competes. Obviously, if Vice President Harris winds up in office, you can expect that non-competes will be banned. If Trump winds up in office, who knows where he's going to come out, given that Matt Gaetz was in support of the FTC's ban. So that being said, there was just recently a resolution proposed in Congress to vacate the FTC's rule. So who knows where this all goes, but we may find ourselves at some point, or at least in some states, without non-competes. We only have 4 states right now: California, Oklahoma, North Dakota, and Minnesota that ban non-competes. So let's turn to what we do with these other types of agreements that might be available. And to kick us off, maybe Mindy Morton, who is in California and can tell us how they handle these issues.
Well, in California, the easy answer is, you can't do almost any of the things we've been talking about. I mean, there are some exceptions, obviously, for trade secrets or for sale of a business. But the California courts are very aggressive in striking down non-competes. And a critical thing that I think not a lot of other states who either have non-compete laws or are considering them, they also won't allow, the courts are not supposed to blue pencil agreements. So if there's a provision that is too broad under the statute, then the whole contract is out and void.
So the whole contract, not just the provision in the contract. So if you have a non-disclosure agreement, non-solicitation agreement, and an invention assignments agreement, all of that goes away?
If it's all in one document?
If it's
Yes.
all in one document.
Yes. There's case law on that. Now, do all judges necessarily enforce that as strictly as others do? No. But we have seen in the state courts judges that are willing to just toss out the entire agreement. And that creates a whole host of other issues, because what happens to that agreement also has severance issues and all of that other issues. And some pretty big tech companies have gotten caught up in that, having their contracts thrown out. However,
why does anybody do business in California? Maybe you can answer that while you're.
Why is what?
Does anybody do business in California?
Oh, well, what I always like to say is California has Silicon Valley. And I used to live on the East Coast, in close to your neck of the woods, Russell, where we had Silicon Alley. And one of the big differences that we see is that not having non-competes really allows employees to go between all these different companies and create new companies.
Steal their trade secrets and move them along.
Well, no, they can't take trade secrets because that's always prohibited. But they can certainly take their knowledge and skill and go other places, and that really creates a system where innovation is encouraged. And we honestly see a lot of the big companies actually investing in companies that their ex-employees have started. And so I think there's a lot that can be said for having that kind of atmosphere where you don't have to be afraid that you're going to be sued when you go to work for a competitor, unless you're taking the crown jewels, in which case, shame on you.
Right, so let's talk about the non-disclosure agreements and how
sure.
you do that there.
So you can absolutely have non-disclosure agreements, and they can certainly go past the employee's departure. And in states where inevitable disclosure is allowed under the trade secret law, California is not one of them, but there are other states like Illinois. You could certainly try to mention in the non-disclosure that any kind of disclosure of these secrets would the employee acknowledges that they would be inevitably disclosed. So that's an option.
But are you saying that would be a violation of California law to put that kind of a clause in a non-disclosure agreement?
Well, California doesn't have inevitable disclosure.
Right, but if you're saying,
so I don't think it would necessarily
recognition.
I don't think it would necessarily invalidate it under the non-compete laws, because I don't think that really interferes with the employee's right to do their trade, because it's just not enforceable. But it's a possibility. I don't think I've seen any case law on that.
Okay.
And I don't know if anybody else has, but
before you move off of the non-disclosure agreements, I want to address California, because California winds up becoming the bellwether a lot of times for states, and it also winds up becoming the most restrictive generally, so people try to write to it. Can non-disclosure agreements in California protect confidential information post-employment? We can have a debate. We have like half the Sedona group, I think, is on this thing, and debating about the scope of what, whether confidential information is broader or equivalent to trade secrets and all that. So just let's take that issue aside for a minute.
Sure. So putting that aside, assuming that confidential information is different than trade secret,
Yeah.
there isn't an exclusion in, section 16600 for confidential information. So I think if we're going by the letter of the law, no, you can't. Now, do I see judges allow that to go by or to enforce information that may not be a trade secret but you can't use confidential information all the time? Yes.
Yeah.
But I think if we're just going by what the statutes and the common law says, no.
Okay, it's important for people to be thinking about that when they're writing them for California.
And I will say there's some kind of controversial cases on this, and the state interpretation of this differs from the federal courts in California's interpretation of this. So I think it's still developing, and I don't know that we have a definitive answer. The California Supreme Court, as far as I know, has not come out directly on this point. So we may see more development on that, because I think that's an envelope that's being pushed all over the United States, not just in California.
Right. Thank you. Anything else on the non-disclosure before we ask Danny to talk about non-solicits?
No.
All right. We'll come back to you in a minute. Danny van der Zanden, you still there?
I am.
All right. Talk to us about non-solicits and no service agreements.
So the language in the rule itself obviously leaves room for non-solicits to be wholly enforceable. The language in many of the comments and the discussion of the comments focuses on that piece of the definition of non-compete that says prohibits or penalizes a worker if they're going to go look for another job or open another business. And so I think that ultimately with both non-solicits and some of the non-disclosure pieces, the real issue is going to be the extent to which the scope of the non-solicit, whether it's as to employees or customers or prospective customers, is going to have ultimately the effect of keeping that person from being able to go and work for another employer. They refer to it, throughout the commentary and the language in the responses to the comments as having, the effect of preventing someone from seeking work or starting another business. So I think a lot of what we have typically looked at when you're trying to make sure that your non-solicit provisions are appropriately tailored to protect the legitimate business interests of the organization that is entering into the non-solicit is going to weigh into this in exactly the same way. And to the extent that those agreements are written in a way that is overly broad and would prevent someone from being able to go out and accept or look for other employment, that's going to be a problem. I do think that I think we're going to have less battle over the extent to which the non-accept versus the non-solicit may be enforceable. But as to the non-solicit itself, it looks like if this actually takes effect in the way that they intend to take effect, so sort of leaving aside all the stuff that we've talked about in terms of the litigation that's going on, the non-solicits are going to be an important way to help protect those interests that are legitimate and protectable.
Awesome. Thank you. Mindy, no recruits or no hires?
Yeah, and again, not sure that you could do it in California. I think that one's a little bit more questionable, but that's certainly another way. Under the FTC, 910.1, it's really something that you can do a lot of things as long as it functionally doesn't prevent a worker from working at all. And so you could argue that that person could certainly take a job and they don't have to hire people they used to work with. So, without any legal interpretation of this proposed rule yet, that would seem to be okay.
Great. And what about disintermediation agreements?
Sure. So that's another area where I think under the FTC, you'd probably be fine. There's a circuit split in the United States. So for those who haven't dealt with disintermediation agreements, it primarily happens when you have staffing companies. And so they'll have a client who asks them to find employees or temporary employees to work at the client's office. And it basically, the concept is they're allowed to say, hey, client, you can't hire these people, or if you do, you have to pay us some sort of penalty, because that's our whole business. And the courts that have looked at these have largely said, yeah, that their business model would die if, they introduce people to these end clients and then the end client just hired them outright, because the staffing company would cease to exist. And so we have the 3rd and 11th circuits that have basically said, yep, that's staffing companies are allowed to do this. Courts in Oregon, Kentucky, Alabama, and Tennessee have also allowed them. The Sixth Circuit in Michigan have been not quite certain if those are okay. So I think, again, this is something that's not preventing an employee from pursuing their work. It's making sure that, you know, the company that they were working for can actually still exist. And I think that would probably be fine under the FTC.
Great, thank you. Last one for you, the invention assignment agreements.
Yeah, and that one, so the concept is, I mean, obviously you're not going to sign inventions that you created before you worked at your current employer or ones that you invent well after you leave. But even in California, you can have invention agreements. And in fact, that's, you know, probably the most common agreement that we see in California is an invention agreement, you know, combined with a non-disclosure. And so that's certainly a great thing to have. And it can protect the company in a number of ways, both kind of by making sure that what people invent while they're working for you stays with the company, but also you can ask employees to disclose what they had previously invented and making sure that you're not then taking an IP that's not yours and making sure you're keeping everything, you know, legal and written out and separate. So there's a lot of benefits to having them. And I think that's a very good solution for companies that may not have had them in the past.
Did I see some case law recently that California has said that people can no longer use or could not use trailer clauses, right? Those you leave and within 6 months, 3 months, whatever, of starting your new working in a new company, anything.
Yeah, there have been some cases on that. And there, again, the concern there is that you might have to reveal the trade secrets of your new company to comply with that. And a lot of companies, they're not going to hire somebody if they have to then turn to their biggest competitor and say, hey, this is what this person just invented at my company. And so that's definitely, I think, I'm not surprised that the courts are seeing that as a restraint on trade in California. So I would be very careful with those kind of trailer clauses. You certainly can try to collect evidence that they're doing bad things. And in, you know, the states that allow inevitable disclosure, that may be okay, but I'd be careful with that.
Okay, great, thank you. Let's turn to some other options. Some of the less common or less commonly used options. Chris Pardo, can you talk to us about notice requirements or what some might call a true garden leave as opposed to just a paid for non-compete?
Sure. First of all, conceptually, the idea of the notice requirements, it seems to be fine. You know, I do think that if you keep it to a reasonable length of time, you put in, and this is someone touched on invalidating the idea of invalidating full agreements through overreach. If you put into an offer letter the notice requirements saying you need to give 6 months of notice, we can put you on the bench. You won't do anything, but it's required. You will pay you 100% of your salary and your, you know, any other compensation that you typically would receive, some average that made the person totally whole. That seems like your best bet. Candidly, from my perspective, it's your best bet to keep people from going to a competitor. Now, there was a question about whether that needed to be bilateral, that there needed to be notice both directions. And I know, and I'm going a little bit quickly because I know we've been at it for quite some time, but I don't know that it's necessary to, if you're going to take the steps of having an employee notice requirement in an offer letter, and putting them essentially on garden leave as a condition of their employment. And then I guess theoretically, if they violated it, you would seek to enforce it. I don't think it needs to be bilateral. There was another question about whether it should be required as a policy. And I think it needs to be in whatever the engagement document is itself, meaning the offer letter, and separate from restrictive covenants, which I think if we're being really conservative, you would separate out certain types of restrictive covenants from each other in order to safeguard one document or one provision essentially being found invalid or overly broad from impacting the potential viability of other restrictive covenants. I would put the notice requirements into the offer letter for that reason, bifurcate out all of the other restrictive covenants. And then as far as having it as a policy, I would not include notice requirements in sort of an employment policy or handbook or anything like that. I would make it specific to the offer letter, to the engagement document.
What's your longest duration you would think would be enforceable?
You know, I mean, it depends on the state, right? But for example, in Florida, you know, you're in great shape if you're going to 6 months, just because of what the non-compete statute there says presently. I think theoretically you could pay someone for 12 months. I wouldn't go beyond that under any circumstance. But you know, it's kind of a broad question when posed that way. So I think that's
well. The reason that I ask that is that, you know, a lot of companies now are considering using notice provisions, right? And just to make sure that everybody's clear on what these are, we're talking about rather than giving 2 weeks notice, the customary notice time that somebody gives before they leave, you know, from the day they resign till the day that their last date of employment is, you require some longer period. And they refer to that. And the idea is that, let's say it's 3 months as an example. During that 3 months, nobody really expects the employee is going to do any work. They're just going to, they're going to sit and basically be on paid leave, essentially. This comes out of England initially. It's called garden leave because the idea is you're sitting tending your English garden because you're not working, right? So that's the idea. And so, so the FTC has said that these are okay. The question is whether state law says that these are okay. And then the question becomes, if they are, what are the requirements? And Chris, your point about looking at Florida and saying, look, Florida allows non-competes for, you know, multiple years. So we can look at that and assume that we're going to be able to have a notice provision of equal length, and certainly anything shorter would be presumptively enforceable. I think it's a fair argument. But we're also thinking about this in a world where even like in, you know, would this apply in California? Because you're not going to you will never seek to enforce through injunctive relief to make somebody work for you. You can't do that. We have the 13th Amendment, that won't work. But you can presumably maybe get an injunction, at least for some people, that says they can't work during that period for somebody else because they're supposed to be sitting on the sidelines. I think Mindy would probably, I think we've talked about this before, I think Mindy will tell me that no court in California will tell somebody that they can't work unless they have special or unique skills or talents for some very limited window, like, you know, actors or something. I see her shaking her head, so I think we can assume that. Steve Kamen, you have your hand up, but before I turn it over, before I ask you what your comment is, I don't know if Chris had anything else he wanted to say on this, and either in response to what I said or anything else.
Well, and that's why I'm suggesting if you're going to use something that's a little bit unusual, bifurcating it out from the other restrictive covenants that are somewhat more traditional, because candidly, if it's going to end up challenged in court, you want the minimum amount of restriction being challenged that you can while you have the other restrictions in a sort of a more secure and conventional format.
All right, thank you. Steve?
Yeah, thanks, Russell. Hi, everybody. I think you've got a conceptual issue and then you've got the practical issue. So the conceptual issue is that once garden leave provisions crossed the Great Pond and became common in America, I think that most of us would say that the purpose of a garden leave provision or a notice provision is to allow the company to require its departing employee to assist with a transition. It's a transitional justification. If you're talking about 12 months, that's a pretty long transition, and I think hard to justify conceptually. And then there's the practicalities. You mentioned paying full comp. Most garden leave provisions that I've seen do not pay full comp. They usually pay just base. And oftentimes they give the employer the right to decide not to pay, to say, oh, just kidding, take a walk.
Right. They waive the notice and then don't pay. Yeah.
So I think if you have a provision that the employer can either hold the employee to it or not at the employer's whim, and the employer can either can pay only base but not full comp, not benefits, not bonuses, not stock options, not incentive comp continuing to vest, incentive shares continuing to vest, whatever. I think it can be argued pretty persuasively that it's really a concealed non-compete. It's not a true garden leave provision. And I suspect that those are going to be roundly challenged in the courts if and when the ban on non-competes is upheld, or in states that have outlawed non-competes when people try to get around them by having garden leave provisions instead, that really are the equivalent of a non-compete in the real world.
Thank you.
So the reason why I suggested and sort of defaulted to the idea of paying full compensation is because the FTC in its commentary actually says that that is not a non-compete. So if we are presuming that we are living in a world where non-competes are outlawed, and that's why I think Steve has that's a very good point, right? It's a better point if non-competes are at some level in the United States permissible. If we presume they are not, I'm just looking to what the FTC's already said is okay, which would be paying the full freight, because then the person is not being prohibited from working for someone else. They're actually, from the FTC's vantage point, and again, I understand Russell's point about the constitutional prohibition of compelling someone to work, but they stay your employee. So they're actually being paid. They've agreed to stay for money, and you're making good on that promise. At least that's what the FTC says, makes it not a non-compete.
So let me, I'm looking at the time. Let me turn to Max, and I'm going to come right back to you, Chris. And while Max is talking, I want you just to think about fixed term contracts and whether there's anything you want to say about those. Go ahead, Max.
Thanks, Russell. So speaking of things that may or may not be non-competes, so in order for it to be a non-compete to be such under the FTC rule, it has to be a term or condition of employment. And I deal with a lot of clients that issue stock options and carry in the venture capital context. And I'm wondering if there's I guess I would put it out there. People have thoughts. You can follow up with me after, because I know we're lacking time. Where there's an argument that a stock option plan, an agreement, could be considered outside the scope of the term and condition of employment. It is the agreement that governs the option and the vesting and the exercise and such. And then same with the GP agreements in the venture capital context, which would be granting carry. So anybody have any thoughts on that? And if you have clients that deal with stock options and grant of carry, please follow up with me if you want to have a discussion. Something I'm focused on.
Yeah. Anybody have any comments on this? I will give people are thinking about it. I think the FTC will say that these are terms of employment. They arise out of the employment relationship. But I hear the argument to the contrary. I think that's going to wind up getting litigated. Vicky?
There have been decisions in Delaware and elsewhere that have said it's simply a condition to a receipt of a benefit. And it depends on if the agreement says that the company can seek injunctive relief if you violate the terms. It's a bit different, and it's been viewed as different by the courts than if the arrangement is, we'll give you something we didn't have to give you, subject to your complying with certain conditions. If you don't get the benefit. Whether that distinction will pass muster with the FTC.
Yeah, and I am talking about agreements that confine the remedy to forfeiture of the benefit provided in the agreement itself, which I think makes the argument a stronger one, if not.
Yep.
Yeah, I agree with you. Recent mass case on forfeitures. We're not going to get into it, but people pay attention. All right. Speaking of forfeitures, Chris, you want to talk about just a straight forfeiture, not a forfeiture for competition, but just you leave, you give up whatever.
Yeah. Yeah, forfeiture for retention, right? Which Russell and I were communicating about earlier today, because for forfeiture for retention without any tie to going to a competitor is the same as it's always been. And that, I think, from the FTC commentary is pretty clear. It's not an unlawful non-compete. I was suggesting earlier to Russell that perhaps, and I think it ties to what Max just asked about, which is if you have incentive compensation, primarily conceptually to me in equity, that you would want to tie to something that is not a non-compete and permissible, like a properly tailored non-solicitation or a properly tailored confidentiality agreement or an NDA, that then had equity forfeiture tied to a violation as a way to try and encourage people who depart not to violate their still in effect restrictive covenants. It would be hard to show it, but there would definitely be a stick behind the threat of non-compliance. I think that could be pretty valuable, because when you're talking about people who, you know, have this kind of equity that it matters, you know, they're probably the same people who have the information that matters, right? Or at least most of the time. So I think that's something to think about.
Yeah, and let me just then I'm going to pick up on one of our other points we were going to talk about, just the notion of the springing non-compete, which I'm just going to deal with it very quickly. The idea is very similar to what you're talking about, except that instead of forfeiting some money for violating these other covenants, you're asking or acknowledging to the court that the court should enter an injunction against you, preventing you from engaging in certain competitive activities. So that's built into the Massachusetts statute. It's built into, I think Rhode Island copied that as well. And so that's something that you might want to think about putting in your agreements. I know Georgia looked at it at one point and said it should be in your agreement. They ultimately didn't pass the legislation, but it's there. Danny Vanderzanden, can you talk to us quickly about, thank you, Chris, about retention bonuses and loans with payback as tools? And then our last topic will be Jim Pooley on trade secret management. And then if people are sticking around, we'll just run the polls quickly.
So retention bonuses, I think you're not going to have a problem as long as they're there, right? It's the non-compete provision only applies after the end of employment. So the longer you can get them to stay, the better a position you're in. The real challenge is going to be if you've got a retention bonus that says you're going to get X if you stay until January 1st, 2025, but you've got to disgorge that if you do something after. That's, I think, likely to be seen as having the effect of penalizing a worker for seeking employment and competition. Now, can you have that retention bonus be well structured so that you've got your non-solicit and your non-disclosure as the things that you use post retention period or post termination of employment to be able to limit what they're able to do? I think you're going to be fine with that. And I would say that the same thing for loans with payback. I mean, the real issue is going to be, these are, at least there's the commentary acknowledges that there's a disparity between what penalizes you for going versus what provides you with an incentive to do something. So that sort of garden leave scenario, right? We pay you to sit on the beach as opposed to go and compete. But for the moment, if you assume that the language goes into effect the way that it is, it would be, I think, probably deemed to be penalizing them for having chosen to compete with the employer. But, you know, I think the best workaround really is going to be to have very well-crafted non-solicits and very well-crafted non-disclosure agreements. To the extent that they're too broad, or, you know, any of the things that we always worry about when we get into the litigation on these cases anyway, right? Is it truly confidential? If it's not truly confidential and you're trying to prevent them from using the information, then it's going to be seen as potentially preventing them from competing. And otherwise, I think that you're going to be in reasonably good shape.
Awesome. Thank you. All right. For the last question, Jim Pooley, tell us about proactive secrecy management.
Yeah, I mean, whatever we may think about the proposed rule here, the rule that we're facing down, it has had the effect of generating conversations like this and bringing to the fore for a lot of companies throughout the country what is it that they should be doing and why should they be doing it, and They're just looking at issues around non-competes. And when we consider not just the issue of a ban, but the existence of state laws that regulate how non-compete agreements or restrictive covenants can be applied, I think we have to face the fact that ultimately the way in which companies can enforce these kinds of things will become so burdensome, particularly for companies that operate nationally or regionally, that they have to focus on something else. And we ought to be there ready to talk to them about how to get over the drug of non-compete agreements and get through the process of understanding what companies can do and should be doing to manage the security of their information assets without the blunt tool of non-compete agreements. And so this is I just want to emphasize the point that this is a really good time to have those conversations about what companies can do proactively to institute policies that will inform very, very good, robust procedures of communication with employees, with third parties and others, that they share their information. So I just think we ought to keep that very much in mind. We have an opportunity here to get our clients into rehab.
Terrific. So thank you, Jim. I mean, it's spoken like a true California, focusing on the absence of non-competes and the drug of non-competes, I think, as you called it. But I agree with you 100%. This is the time, and people should really be thinking about these issues. I'm going to do a wrap up, and then I'm going to run the polls. So for anybody that wants to stick around for the polls, please do. But let me first just make sure to thank everybody who has attended. Thank you to the panelists for all their participation. A recording will be available within the week, and I'll put it up on my blog, faircompetitionlaw.com. I suspect it will be up on others' websites as well. It will be available directly through YouTube, though finding it may be hard. If you have any questions, please do not hesitate to reach out to any or all of the panelists for any follow-up questions. I'm sure everybody here would be happy to answer whatever questions people may have. And remember also, as I mentioned at the beginning, Eric Wybust and a few others and I are putting together an amicus brief, which we expect we will file. And if you're interested in being included as an amici, please let us know. So with that, let me launch a poll here. We'll see how we do this. The question is for the lawyers here. Which option are you going to recommend to your client? Any of the few there, right? So comply with the notice requirements. Can people see this, I assume? Yeah. Comply with the notice requirement with no changes. Ignore the notice with, issue the notice, but with reservations. Ignore the notice entirely. Intervene in one of the cases, presumably the Ryan case, or sue the FTC yourself. And looking at the numbers, it appears that most people are going to issue the notice with reservation. And I'm guessing that's Scott McLaughlin there, who's ignoring the notice altogether. Yeah, we've got some people. Looks like most people are going to issue the notice. We'll give it just another moment or two. And we've got some people who are going to comply without changes. On the second question, the company, this is just for the companies, not the lawyers. Are you going to comply with the notice with no changes or issue the notice with reservations? Same issues. Ignore the notice requirement, intervene in one of the cases, or sue the FTC. And looking at this poll, at this point, it looks like we've got the majority of people are going to issue the notice with reservations. The balance of the majority of people are going to comply with the notice, and then we have a few who will ignore the notice altogether. That's the lawyers, not the companies, which is an interesting dichotomy. So, all right, I'm going to, just in the interest of time, end the poll. Thank you all very much for your assistance, your attention, and again, we're all here if you have any questions, and it'll be up and available to watch. Thank you.